Welcome, everybody. My name is Larry Newman. I'm the co-editor with Ed Mullins of this book, which we're launching today and celebrating today, together with authors of all 9 chapters. So there's a little bit of background. We're talking today about Section 1782, which has become an increasingly important part of international litigation. I can remember back 30 odd years ago, back in the 1990s, when I discovered the existence of 1782, I really couldn't believe that it had all of the capacity that it seemed to have. And around that time, hardly anybody knew about it. And David Zaslowski, who's authored one of these chapters, and I went to London to speak to the Law Society, and everybody, we would trying to get them to take advantage of this. And eventually, as today, we are seeing increasingly large number of cases growing every year, it seems, and including a very important Supreme Court case, which is included in our book. So the book does recognize that there will be changes in this field, rapid changes. As a result, purchasers of the book will also get a subscription to updates, online updates, for the first year, ending June 30th, 2021. So, as I say, all authors of all 9 chapters are here. They're going to present highlights of their chapters together with slides, PowerPoint slides. And following their presentation, there'll be an opportunity for questions, which I believe you will be able to send to us through the chat room anyway. And we'll try to perhaps get people to reflect in their answers some of the questions that you do raise. As you may know, there's a 20% discount on purchasing the book, but at the end of the session today, all persons present will be eligible for a drawing that will take place, I guess, through some kind of machine learning capability, in which 2 books will be given out free. So stick around to the very end and see whether you're one of the lucky winners. The first part of this program will be moderated by Ed Mullins, and then after he is also one of the authors, and after he speaks, then I will be taking over as the moderator. So Ed, do you want to take over from now?
Yeah, welcome everybody. My name is Ed Mullins. I am a partner in the Miami office of Reed Smith. And something, just really, let me first show you the book. If you haven't seen it yet, here is a look. It is a real book, and it's really great. This is actually the first opportunity that I've had to co-edit a book, and I'm really excited about it. We've done a lot of 1782 work in our firm, and so what we did, what Larry and I put together was it's sort of unique. There are law professors on this as authors, but we also have a number of practitioners. Everybody has intensive experience in this, and the purpose of this is introduce you to what each chapter of the book is, and hopefully that you come out of it realizing that this is a must-have if you are interested in international litigation. And everybody should, anybody does any litigation is an international lawyer in today's world. There are every case you have is some international component, and certainly that's true down here in South Florida where I practice. And so I think this is a must-have volume. I do say so myself, and it's only because of the wonderful authors we have. I think you'll come out of this hopefully learning something today, but you'll have to buy the book to get all the secrets. And so with that, let's go ahead and get started with our first chapter 1. Author is Robert Smith, who's also co-author there with Lauren Brazier and Tyler Robinson. So we can go to the next slide just to talk a little bit about Robert. As it shows there, Professor Smith, is an adjunct professor at the Columbia Law School and a retired partner and chair of the International Arbitration Practice, Simpson Thatcher worked as an independent arbitrator, and his accolades all speak for themselves. We're delighted to have him as our first speaker and our opening author, chapter author here. So we go to the next slide, and I'll turn it over to you, Robert.
Okay, I'm going to just talk briefly about the history of Section 1782. For 150 years, Congress has been struggling to figure out whether and how federal courts should help foreign tribunals get evidence located in the United States. And Section 1782 is the product of that struggle, and it's also very personal for me. And it's personal for me because my father, Professor Hans Smit, conceived both Section 1782 and me in 1958. 1958 was the year he married my mother, and 1958 was the year he was appointed to spearhead Congress's efforts to overhaul the various statutes governing evidence gathering for foreign tribunals.
So literally 1782, and you are his baby.
We are his babies. I think he's more proud of Section 1782, though, but for good reason. For good reason. It took him 6 years to generate Section 1782 after he was first appointed. It took 9 months of labor, mostly my mother's, to generate me. But in any event, I want to focus on Section 1782. In 1958, Congress formed the Commission on International Rules of Judicial Procedure, and its mandate was to study and recommend ways to improve judicial cooperation between different countries with respect to international litigation. But the problem was Congress didn't give any money to the commission to do its work. So the commission turned to Columbia Law School, where my father was teaching, to fulfill its mandate. And my father was appointed to spearhead the Columbia Project on international procedure. He ultimately acted as the reporter for the commission that enacted the Section 1782, but he was assisted by Justice Ginsburg, Judge Ginsburg, Professor Ginsburg at that time, who he brought to Columbia Law School, who worked as the associate director on the Columbia Project, and who was kind enough to call my father the dominant drafter of Section 1782. My father, never, a shy guy, calls himself and his law review articles the legislative history of Section 1782. Fortunately, we have a 2004 Supreme Court decision, still the leading case construing the scope and application of Section 1782. And the Intel case addressed, many of the issues that had arose over the 40 years since Section 1782 was first addressed, and others will speak of the various issues that were addressed. But what's key is that there is a famous footnote in the Intel decision citing to one of my father's articles, and it's oft quoted dicta, saying that Section 1782 is also available to obtain evidence in aid of international arbitration. And anyway, next slide.
Yeah, I was going to ask you a question before we get to that slide.
Sure.
So, I mean, what you said of the statute was passed in the 60s, and then, we don't see a Supreme Court case for a number of years. Was there a change in the litigation once Supreme Court ruled, or how active was the statute?
Well, I think there are a number of reasons to explain why it took 40 years for the Supreme Court to get involved. One of which is that people, as Larry alluded to originally, people didn't really know about Section 1782, especially since typically you use Section 1782 to obtain discovery of American parties. Foreign parties wouldn't necessarily know about the availability of Section 1782. And I, as I imagine many of you, have done many marketing trips around the world to advise people of Section 1782 and to encourage them to use our firms to try to get evidence against their adversaries in foreign litigation and arbitration. And then, I don't want to step on others' toes because they're going to talk about the specific issues that arose under Section 1782. But it took 40 years to reach the Supreme Court. It might be reaching the Supreme Court again this very month.
Can we go to your last slide? I think we back. And so I got you off track. So you're about to tell us about the two policies, 1782.
Yeah, I just wanted to, I wanted to launch the rest of the discussion by talking about the twin aims of Section 1782. The first was to provide efficient assistance to participants in international litigation. And whether Section 1782 can realize that aim will really depend on how the district courts who are called upon to apply it balance the genuine need of foreign tribunals for evidence against the real dangers of imposing burdensome U.S.-style discovery on those foreign proceedings. And the second aim, dear to my father's heart, was to encourage foreign countries by example to provide similar assistance to U.S. courts. Personally, I'm not so sure that second aim is realistic or realizable because I'm not sure that the United States really is the role model in the international litigation community that my father imagined. But again, I think others will talk about similar provisions in other
I think it's actually a good segue to our next speaker to find out if these twin aims were met, and we're going to go through each of these chapters. So I'm going to go to our next speaker, who's going to be Tim Nelson. Before Tim talks, let's give you what he's going to talk to us about first, before we get to these twin aims, is what 1782 is not and how it compares to other things. Tim is a New York partner at the Skadden Arps firm and been a co-counsel of me, is very adept in international arbitration, international litigation. And unlike me, he has a different accent than I do. And you'll find out in a moment if you don't know Tim. Tim, are you with us? Getting ready to start off and talk to us about chapter 2.
Thanks very much, Ed. And thank you, Rob, and Larry, for your insights. And thank you also to my partner, Greg Litt, who contributed this chapter with me as co-author. As Ed said, I've done quite a bit of 1782. I've tended to be on the defense side. So to Rob's point about the famous footnote, it's been my task to explain why the famous Smith footnote in Intel should not be given a wide interpretation, but that's for another day. It's but it's a tribute to his father that his writings continue to be of such importance and mentioned in virtually every 1782 brief that's ever been written. What 1782 is can be understood, and this is what our chapter deals with, by looking at what it is not and where it is. And we've made the point in our chapter that Section 1782 is bookended by two other statutes that tell you a lot about context. One is Section 1781, which together with 1782 facilitates the system of letters rogatory. The conventional, sometimes known as the Hague Evidence Convention, means of courts around the world cooperating with each other. And the second neighbor of Section 1782, Section 1783, is a rather extraordinary statute that allows the United States courts to send subpoenas to US nationals overseas. So it tells you that, and I think all of these chapters, all of these provisions were part of the general project, the Columbia Project. But if we look at the next slide, I've done a little comparison of the alternative to Section 1782, and none of them have the same, nothing compares, like Sinead O'Connor, nothing compares to Section 1782. The Hague Convention allows foreign litigants to come to the United States and enlist the cooperation of United States courts, but it's really, the Hague Convention is really about getting trial testimony and trial exhibits. It is not about US-style discovery. and US style depositions and all of the panoply of e-discovery that comes with a subpoena issued by a United States court.
So if I was in the audience and I wanted to know, when would I want to use a 1782 as opposed to, using the Hague Convention or some other of these alternatives?
I think you would be hard pressed to tell a client to use the Hague Convention in lieu of Section 1782. Others might disagree. So it just shows how special the statute is. But the difference is the Hague Convention is reciprocal. It's a mutual deal, whereas 1782 is unilateral. It's only available in the United States. There's no real equivalent overseas. So the idea of there being this utopia of every country having it is, with all due respect, didn't come to pass. Diplomatic channels, just on this slide, you can get, say, the British Embassy to call a British national resident of the United States to come and answer a few questions in the consulate. And there are actually laws that facilitate that in the United States to give it that request force of law. But that's a much narrower mechanism than 1782. And finally, the only reason I mention extraterritorial subpoenas is just to sort of show how limited that concept is. You can get a US court in very limited scenarios to issue a subpoena to a US national living overseas, and you could even force them to come back to the United States and testify in US courts. It's very rarely done. But I'm not aware of any instance where a foreign country has, through its laws, given its courts the power to do that to someone in the United States. There is no way you can get a French court, to my knowledge, to validly issue a subpoena enforceable in the United States. So it's just yet another illustration that this statute of 1782 that allows you to target a subpoena against anyone found in the jurisdiction and get the full panoply of US discovery and depositions against that person, really unique.
Tim, you are in fact my favorite author here. Unfortunately, I have to move on to my other favorite authors.
Okay.
So unless you have, because we move on. So I am. But I will again tell the audience, if you have any questions, please use the chat. I am monitoring it, and we can always go back to anything you want to talk about. So far we've learned who was the brainchild of 1782. We've learned what it's not. So now we're going to start talking about, the various issues that have come up, and you're not going to be shocked to learn that despite the fact the U.S. Supreme Court wrote this opinion, there has been litigation post then, and that's what the rest of the book is about, and I think you'll find it very interesting. So our next author is Leif Simonson. Leif is a New York partner as well. He's a principal of Coburn and Kim in the New York office. He also is very adept at international litigation. Leif and I worked together with the ABA Center for International Laws, where I met him principally, but I've done some work with him as well. And so I'm going to turn over to Leif, who's going to talk about the for use requirement in Section 1782.
Oh, thanks very much, Ed, and welcome everyone. So as Ed mentioned, my chapter is on the statutory requirement that the evidence to be obtained through 1782 be for use in a proceeding before a foreign tribunal or international tribunal. And this requirement, like many of the statutory requirements and discretionary factors that 1782 applicants face when they're making an application, this requirement has raised a number of interpretive questions that the courts have, to some extent, resolved to a varying degree, and then left it to the lower courts to continue to apply on a case-by-case basis. So first, does the foreign proceeding have to be pending at the time of the application? Second, does the evidence have to be discoverable under the law governing the foreign proceeding? Third, does the evidence have to be admissible in the foreign proceeding? And fourth, what must an applicant affirmatively show to satisfy the for use requirements? And so my chapter addresses each of these interpretive questions and how the courts have dealt with them. So first on the timing requirement, whether the proceeding has to be actually pending, there had been prior to Intel a circuit split on that. Some circuits had said that the proceeding, while didn't have to be pending because that word was actually removed previously from the statute, it had to be imminent. Other courts said that it had to be very likely to occur. The DC circuit, and it was Judge Ginsburg actually, when she was on the DC circuit, came out with a decision and actually quoting Professor Smith, Rob's father, stating that it had to be within reasonable contemplation. And so then in 2004, when the Supreme Court in Intel faced this same question, Justice Ginsburg authored the majority of the opinion, and there the court famously held that the proceeding didn't have to be pending or even imminent. It just had to be something that was within reasonable contemplation. Of course, this is a loose standard.
I'm sorry to cut you off. Let me just stop you there. The one thing I thought was pretty interesting what you said is, so, and by the way, we're hearing some feedback, so if you're not speaking, if you can put on mute. So unless you're speaking or one of the moderators, we're hearing some noise there. So please put on mute. All right, so anyway, one thing you were talking about was this reasonable contemplation. And if I understand it, in domestic litigation, I don't have the right to say, I'm thinking about suing somebody, so I want to take discovery over you, bank, because I think you may have bank records and I'm, interested in suing. Is that literally, if I just have this idea that I might want to sue somebody and I think some bank has evidence, I can actually do something about that?
No, the courts have sought to tighten it up from that. Of course, that's been attempted and continues to be attempted. But since the reasonable contemplation standard was announced by the Supreme Court, this still comes up. And courts have generally said that it has to be something that's more than just speculative, and that there has to actually be some reliable indications that the applicant will be launching the proceedings. And in relatively colorful language, the Second Circuit has said that it has to be something that's more than just a twinkle in counsel's eye. It has to be something that
have all the circuits been consistent about that? Is that the standard, or you might find some lower standard in some other circuit, say, I don't know, 11th?
Yeah, exactly. I think that you will find varying standards across the different circuits, and but nevertheless, I think that there is generally it has to be some objective showing. You can't just assert that this is something that you're thinking about bringing. There has to be something that you can point to demonstrate, even beyond just hiring counsel, that you're contemplating proceedings. But what you need to show, it still is something that the courts are wrestling with. Just shooting through, because I know I have limited time, the other interpretive questions. The next one was on whether it's something that has to be discoverable in the foreign proceedings. And before Intel, the courts were divided, but Intel made it very, very clear that it was not something that had to actually be discoverable in the foreign proceedings. And the court reasoned that if this is something that Congress had wanted, it would have made it explicit in the statute. But nevertheless, courts still wrestle with how it should consider foreign discoverability. And as you'll hear later, one of the discretionary factors that the courts consider when they're considering a 1782 application is whether the request conceals an attempt to circumvent foreign proof gathering restrictions. And this is a little bit in tension with the conclusion that you don't have to show that it's discoverable in the foreign proceedings, but nevertheless, the court should consider whether it's an attempt to circumvent foreign proof gathering.
But what would it be an example of that, you think?
Well, so it's something where courts have said it can be considered in the discretionary factors, but it can't be the sole consideration. But if the courts would distinguish, at least several cases distinguish between, is it something where it affirmatively there's a policy, an affirmative policy against something being discoverable. I mean, an obvious example is privilege, but something beyond that, versus the foreign jurisdiction doesn't have a procedure that enables the discovery. So in that case, that's not going to count against the applicant, at least under the statutory requirement. But if there is an affirmative policy against it being discoverable, then that could nevertheless still be considered by the courts. And then on the foreign admissibility there, that wasn't actually addressed by Intel, but courts have consistently held that it doesn't have to actually be admissible. And if there's a debate about whether it's admissible, I mean, really the courts just didn't want to be engaging in a battle of the experts that it was facing, where experts would come and say what the foreign requirements were. But nevertheless, it's something that can be considered in the discretionary factors. And then finally, on what's affirmatively required to show the for use, as my chapter kind of lays out, it's really not well developed. The courts have looked to the basic relevance requirement of Rule 26, the Federal Rules of Civil Procedure, but nevertheless, some courts have, including the Second Circuit, had said that relevance is not sufficient, and it has to be something that the applicant has some means of being able to inject into the proceeding to its advantage. So, this is something that remains very much an issue, and so stay tuned for further updates to this chapter on that topic.
Perfect. Well, we must be doing a great job with the presentation, because so far we have no questions. But again, if you have anything for our authors, please, don't hesitate. But I'm going to turn it over to our next speakers. And our next speakers are going to talk to us about what is a foreign international tribunal outside of the issue of international arbitration, which actually has its own chapter, which we'll get to later. Our next speakers are Annette Escobar and Arnie Lacayo, who are, it turns out, worked at an outstanding law firm. It was the best law firm ever. One that founded it with my former partners, and so they actually are my former partners, and now they show up on other sides of the cases sometimes. But Arnie Lacayo is a former chair of the International Law Section and at the Florida Bar, is a well-known international litigation arbitration practitioner, mostly international litigation. You will not hear him say that he does mostly defense work, contrary to you hear from Tim Nelson. And Annette Escobar, also one of my former partners, also is well versed in international litigation arbitration issues. She is board certified with me as one of in its current chair. I guess she ends, or she just ended, for last week, but the International Litigation Arbitration Certification for the Florida Bar. And so without further ado, I'll turn it over to Arnie and Annette to talk about what is a tribunal you can use this stuff for outside the international arbitration arena.
Yes, Ed. An international tribunal is the language used currently in 1780 in the statute. The statute previously used the words judicial proceedings. Shortly after the amendment to the statute, that's when Intel was decided to interpret those terms, and Intel came out with the standard first instance decision maker. Obviously very vague and subject to interpretation, so there's been extensive litigation after that as to what that means. The district courts and the courts of appeal have come up with various different standards. They have said that the case has to be quasi-judicial in nature and set forth several factors that are considered in that analysis, including whether a dispositive decision can be decided now or in the future, whether there will be further judicial review at some point of the final decision made by the entity, and whether it can gather information that can be used later on in the case. Arnie will discuss in detail more as to the specific instances or cases in which these decisions have had to be made, particularly outside of the arena of civil, criminal, and commercial, which are fairly obviously included within a tribunal or a court. Arnie?
Thank you, Annette, and thank you, Ed. I don't want to forget to thank my colleague Raul Torao, who was one of the co-authors for Chapter 4 and a great help to us as well. Picking up on where Annette left off, it is correct to say that the Supreme Court in the Intel decision made clear that you did not need a traditional tribunal looking at civil, commercial, or criminal matters to look to 1782 for evidence gathering. In fact, the court there ruled that the ambit of the statute included administrative tribunals and quasi-judicial agencies, as Annette said. Subsequent to that, and maybe we can move on to the next slide. Subsequent to that, we've had a number of decisions that have found that family courts outside of the United States, bankruptcy courts outside of the United States, probate courts, all of these also qualify as a foreign or international tribunal under the statute. Beyond that, there have been some interesting questions raised in a number of these 1782 proceedings with respect to other bodies and whether they qualify as foreign or international tribunals. And these decisions coming out from across the country have resolved mainly in favor of allowing the use of the statute to support proceedings before patent offices, for example.
Well, Arnie, let me just stop you real quick. So I'm looking, for example, you got bar associations and things that may or may not have the subpoena power themselves. So are you literally saying that, just hypothetically, I don't know, let's say there's a Brazilian bar association and they're investigating, some attorney, and then it turns out that, that attorney thinks there may be, some documents that are relevant to his defense here in the United States. Are you saying that even though he would not be able to get such a subpoena from the Bar Association, he might be able to get one here in the United States? Is that right? And does that make sense?
That is right, Ed. Most of these opinions from the courts have looked at other issues, but not the issue of whether the foreign or international tribunal has the power to subpoena a third party. Most of these decisions have looked at the issue of whether the body is charged with resolving a dispute, collecting or reviewing evidence, and permitted to make some sort of decision that can then be reviewed further. In the case of the Patent Office, that was the case. In the case of the Korean Trade Commission, which is the case that caused us to put that bullet point up there, the court held that the commission held hearings, made final determinations as to whether a party violated an antitrust regulation, had the power to make binding orders, award monetary sanctions, etc., but did not really look at the issue of whether they had the ability to subpoena a third party. In the negotiable instrument bullet here, that was an entity, a Saudi entity, that was able to make binding decisions on negotiable instruments and so forth. With regard to bar associations, we saw the British Administrative Court at the High Justice in that particular case as the foreign or international tribunal. No discussion about whether they were able to subpoena, but again, a focus on whether they were able to make binding decisions. And as reflected in the chart, the one area that has been, of course, segregated from Chapter 4 is the issue of arbitral tribunals, which we will have another author discuss. And we found at least one case where a conciliation body out of, in that case, Cameroon, was found not to be a foreign or international tribunal under the statute. The bottom line is that the district courts, the circuit courts, have expanded the scope of 1782 in this manner by finding that foreign bodies charged with making decisions are really foreign or international tribunals under the statute. And I think that's the trend and likely to continue.
Perfect. So at this point, I'm going to switch over the reins of the moderation to my co-editor. I thought I might have a scheduling conflict, but it turns out that I don't. So I'll be here for the duration. But we did agree that I would turn over the reins of the presentation to Larry Newman. So I am now going to do so.
As you can see on the screen, the authors of Chapter 5 are husband and wife team of Rima Mullins, an assistant professor of legal skills and values at Florida International University School of Law, and Ed Mullins, who is a partner of Reed Smith. And they're going to be talking, they talk in their chapter about found in the district, statutory requirements rooted in personal jurisdiction, as you can see. And perhaps it's my understanding that perhaps the most friendly jurisdiction happens to be Florida, or at least the 11th Circuit, where courts are perhaps more generous as to who determining as to who is found in the jurisdiction. But Ed, will it be you or Rima who will be talking?
I think Rima's going to start.
Okay, go ahead.
Rima, you still there? Did we lose her? Are you on mute?
I muted myself because of all the other. Thank you, Larry. This chapter really addresses who the movement can get discovery from under 1782. So the statute authorizes the court to order discovery from a person who resides or is found in the district in which the court sits. But the statute doesn't actually give any indication of exactly what that standard means. So not surprisingly, courts have taken different approaches. Some courts, particularly the Second Circuit, have adopted sort of the principles of personal jurisdiction to evaluate the found in the district requirement, which has led to some kind of what I think are weird results where, for example, the Second Circuit has found that you can exercise tag jurisdiction. So in the case that everyone cites from 2002 in Ray Edelman, the court found that a French corporation who was suing a French citizen could bring a 1782 action against them in New York because the French citizen was on vacation there and was served with the subpoena. So in doing that, the court basically said, if that's enough to be able to exercise personal jurisdiction over a defendant, it's enough to be able for someone to be found in the district under 1782. Other courts use the language.
Go ahead.
That doesn't work for corporations, I gather, under tag jurisdiction.
It does not work for corporations. Tag jurisdiction only works for individuals.
But what makes no sense about it to me is that a subpoena, it doesn't work for a subpoena. So if you have a lawsuit here in Florida and you happen to get a witness here they're on vacation and say, okay, well, I want to force you to take a deposition here, they don't have to come. They get to pose under the case law where they live or where they're working. They don't have to, just because you got them here in a subpoena. But the 1782 has been interpreted as if you got them, so you have a person from a foreign country who happens to be visiting here, and you get them, and they've got to defend a deposition. It's really unique.
I think it's the rationale of the Second Circuit anyway is that it's more akin to personal jurisdiction than akin to Rule 45. But I agree with you that it's kind of wacky. Other courts have used the language of systematic and continuous business activity, which is kind of a personal jurisdiction concept, but then not really engaged in the personal jurisdiction analysis. So for example, in the Ninth Circuit, courts found that if an entity had an office in the district, it was found in the district. This difference in approach has gotten more significant over the last few years as the Supreme Court narrowed the scope of general personal jurisdiction. So in 2004, the Supreme Court in Daimler versus Bowman limited the exercise of general personal jurisdiction over foreign corporations and held that you had to show more than continuous or systematic business activities, which is the standard that those courts used. You had to show that the corporation's activities are such that the corporation is essentially at home in the state, which is quite a high burden. And then 3 years later, the Supreme Court said that that Daimler standard applied regardless of the claims asserted or the type of business sued. So post-Daimler, the Second Circuit has basically taken the position that Daimler controls how to determine if an entity is found in the district under 1782, making it
I'm sorry to cut you off. Go ahead. I'll have a comment, but go ahead.
Okay, making it very difficult for movants to establish general jurisdiction over a foreign corporation in the Second Circuit.
Yeah, so what I was going to say, Larry,
Using that same analysis, though, go ahead.
Go ahead. Go, please. We just like the way it is at home. Go ahead, please. No, you had finish.
Using that same personal jurisdiction framework, though, the Second Circuit issued an opinion late last year where it said that a movant could establish specific jurisdiction over a foreign corporation in order to show that the corporation is found in the district under 1782. If they can show that the entity's contacts with the forum were the proximate reason for the evidence sought to be available in that forum. Oh,
Yeah, so
go ahead, Ed.
What I was going to add to all this is I don't necessarily agree with Larry that the 11th Circuit is more liberal on this particular issue. It has on other issues we're going to get to later in different chapters. But I think the Second Circuit actually has been the leader on this and been very aggressive on this. And it's a big issue because as we're going to see in later chapters, you get a little bit of forum shopping because what ends up happening is that not because of the found in the district, but they want to be here for other reasons of the decisions from the 11th Circuit as to access to documents, the control issues we're going to talk about later, and they'll want to say you're found here. And the question is, are you really found here? And for some clients that have been faced these things, we don't necessarily say that every bank account, wherever it's seated in a bank account somewhere in the United States, just because they have access here, that Citibank, Chase Manhattan Bank, whatever it is, are all found here in the district, because it becomes a critical issue as these circuits have diversed into what their what standards they're applying to other factors in the statute. Go ahead.
Well, what is interesting is I think that, for example, the Second Circuit, if you're trying to exercise if you have a corporation and you're trying to get documents and you could not show specific jurisdiction, you're kind of out of luck in the Second Circuit. They're very strict about it, but they're very generous with the idea that you can exercise specific jurisdiction. So it really depends on the facts. I would say the Ninth Circuit is pretty friendly in this particular issue because they have continued. They don't apply Daimler. They have continued to follow the cases that they had prior to Daimler. Even though they use the continuous and systematic language, they're still finding that a target is found in the district if there's an office in the district. And there is at least one court in Florida that totally rejected the idea that Daimler controlled because they said that 1782, the availability of the discovery shouldn't be subject to different state rules. So they seem to find a concern that there would be forum shopping if you're looking at all of the different state rules. I think we're
and Rima and Ed, I think we have to move to the next
way
chapter.
past our time. But
So thank you very much. Let's go to chapter 6. We can get the screen up. Possession and control under the Federal Rules of Civil Procedure by David Cohen and Bradley Whitecap, both attorneys at Reed Smith. This has to do with the production of documents that are within the parties' possession custody or control, and how is that interpreted under Section 1782? So go ahead, gentlemen.
Thank you, Larry. This is Dave Cohen. I'll start. And I think the discussion so far has covered when and to whom Section 1782 applies. And this chapter deals with to what documents does 1782 apply. And 1782 specifically states that unless an order issued under 1782 provides otherwise, that the procedures will be governed by the federal rules of civil procedure. And so we looked at the federal rules of civil procedure and Rule 26, and in particular in Rule 45 that covers subpoenas. And they say that a party can be ordered to produce documents within its possession, custody, or control. So those are the magic words: possession, custody, or control. Possession and custody are pretty easy to determine, but different courts have come up with different interpretations of what it means to be in control of documents. So courts in a number of circuits have applied a legal right standard, which is to say that you are in control of any documents that you have the legal right to. So for example, if you have a contract with another party and that contract gives you the right to certain documents, then those documents are within your control and you may have a duty to produce them. You do have a duty to produce them under Section 1782. That rule has been cited and adopted by cases in the 3rd, 5th, 6th, 7th, 8th, 9th, 10th, and 11th circuits. But courts in other circuits, and in fact some of the courts in the same circuits, have gone beyond the legal rights standard to adopt the practical ability standard. And under the practical ability standard, your duty to produce documents is expanded to not only the documents that you have a legal right to, but also any other documents that as a practical matter you can obtain. And this leaves a lot of discretion in the part of a court to determine what documents you have the practical ability to obtain. So if you have a close relationship with another party, if they are an affiliated company, if a court determines that as a practical matter you could get documents, then those documents are also considered to be within your control. That legal right standard has been adopted, that practical ability standard has been adopted by cases in the 2nd Circuit, the 4th Circuit, the 8th, the 10th, and 11th circuits. And note that the 8th, 10th, and 11th, other courts have cited to the legal rights standard. So there's a little bit of a division even within particular circuits.
But David, let me ask you a question. So are you saying, I just want to understand, what you're saying is if I had a case in Germany and I thought there were bank records in Germany, but there was a bank account in New York and the bank branch in New York, and they had access to as they do to all the accounts in Germany, that I could file a 1782 and say, well, I want in New York, you say, I want the documents produced here in New York because you have access to them in Germany, despite the fact that the documents actually are, it's a bank account in Germany. Is that going to work?
That very paradoxical situation can work and sounds suspiciously like a case that you and I actually had with a German party trying to get documents in Germany by coming through the U.S. And what can complicate it is if it's not necessarily the same bank, but maybe the German affiliate of the U.S. bank, then you get to that question, well, is that U.S. bank in control of those documents if it's an affiliate? And that could turn on a judge's interpretation. It could be a question of, is that German bank the subsidiary or is it just a sister bank? So those kinds of questions come into play. Then the final standard that has been applied in some jurisdictions is the legal right plus notification standard, which requires you to produce any documents that you have a legal right to, but also notify the requesting party if you're aware of any other documents within the possession of a third party that would be responsive to the subpoena. So that's been adopted by the 1st, 4th, 6th, and 10th Circuit. And then also in answer to your question, Ed, I think that what Brad's going to cover, which includes the extraterritorial reach, may also be relevant to answering that question. So Brad, you want to say a few things about that?
Sure. As has been discussed earlier, the the Intel case is obviously the most important case when it comes to 1782, and Intel dealt with documents held within the U.S. As can be applied to a foreign litigation, and so that's generally accepted. However, there has been a bit of a disconnect when it comes to documents in a foreign litigation that are also held outside of the United States. And a 1964 Senate report stated that the statute was intended to aid in obtaining oral and documentary evidence held in the United States. And additionally, there was a comment to the statute saying that construing the statute to reach evidence abroad would make United States courts clearinghouses for discovery and litigation around the world. So it seems like the initial intention of the statute was intended to only reach documents that were held within the United States. However, more recently, the 11th Circuit in 2016 in Sergeva v. Tripleton held that since the Federal Rules of Civil Procedure did not place a geographical limitation on discovery, there was no per se bar to discovery of documents held outside of the U.S. under 1782. And this argument was also agreed upon by the Second Circuit in 2019 in Rey de la Valle Ruiz, that also agreed that 1782 could reach documents held outside of the United States. So the initial judicial history, or not judicial history, but the initial statute seemed to indicate it was only for U.S. held documents, but the more recent judicial history has extended that to documents held outside of the United States. And that brings about all kinds of other issues, in particular, potentially violating the local laws of those other jurisdictions, such as the personal privacy laws in Europe under the GDPR, or banking secrecy statutes, or other things of those nature. So you have to be careful when trying to apply 1782 that you aren't inadvertently violating the international laws of the other jurisdictions.
Yeah, I think we should move on. I just have an announcement that for those of you who are interested in CLE, there's a code word you should bear in mind and make use of at the appropriate time and place. June, J-U-N-E. So write that down, keep track of it. Also, you can use the chat room to send questions if you have questions. We now go to Chapter 7, Discretionary Factors under Intel. The authors of that chapter are Bruce Mark and Tom Sullivan. And you guys want to go ahead?
Sure. So once you get past the statutory factors, that's generally only half the battle in 1782. What comes next are these discretionary factors that the court, Intel, laid out for what district courts can consider. And the reason why it's discretionary is because 1782 says it authorizes but does not require a federal district court to provide judicial assistance. And they wanted to set this up so the courts would exercise this discretion within the twin aims of the statute, which is to provide means of assistance to participants in foreign litigations and encouraging foreign countries to provide similar assistance. While the court in Intel, they set out a framework of these discretionary factors, they did not articulate burdens of proof or any specific legal tests or standards for application. So that leaves the district courts as not having a hard formula for weighing these factors, but just that they go through the factors and they develop some of their own standards since then. First big factor is whether a party from whom the discovery is sought is a participant in a foreign proceeding or already subject to the jurisdiction of a foreign tribunal. This focuses really on not the location of the discovery target, but whether the evidence would be within the reach of the foreign tribunal. So they would look at first whether the discovery target is a participant in the foreign proceeding or a non-participant. Obviously, if the the discovery target may be here in New York or Florida, but they're also in Germany, that party could be within the jurisdictional reach of that court or tribunal, and maybe they can then have to be required to produce that evidence. That would make the need for 1782 less strong, as opposed to a non-participant where you're just, say, a bank in New York and you've got wire transfer records and no other ties to the foreign jurisdiction. That weighs in favor of the discovery, because 1782 may be the only way these participants or the foreign tribunal can get at this evidence. The second factor is pretty broad. It's the nature of the foreign tribunal, the character of the proceedings underway, and the receptivity of the tribunal to judicial assistance. Now, it's the nature. Courts have looked at a couple of different issues. They've looked at whether these proceedings may be terminated shortly, so there's really no reason to get into 1782.
Now, we have your factors on the slide, right? Can we look at those?
Sorry, yeah, go to the next page, please.
Yeah, so we can look at them while you're talking. There we go. We see the factors. Yeah, go ahead.
They said. So I'm on factor 2 right now. So the nature of the proceedings also may include whether or not a tribunal is considered these requests in that foreign proceeding and said no. And then sometimes people come to the U.S. and try to get them here, and sometimes the courts will say, well, the German court didn't want you to have it, so maybe that weighs against us.
So going to that, so you say no foreign admissibility. So in other words, using the hypothetical I gave earlier, even if it's not admissible in the court where you're trying to use it, you can actually get this discovery. Is that what you're saying?
That's right. There's no, and that kind of ties in receptivity. So a court may, like Germany, somebody will correct me if I'm wrong, they generally don't permit depositions. Well, you can get a deposition here. So people make the argument, well, you can't take a deposition in Germany. Why should you be able to take it here? And that's not a standard. The standard is whether or not will be useful in the proceeding, and that's to the participants, and that may help gather evidence that they may be able to submit to that court. It's not a question of whether it would be illegal to take a deposition in Germany, therefore you shouldn't take it here. The courts don't get into that. And for receptivity, what the courts will look for is really not a lack of available discovery, but an authoritative statement from the foreign proceeding that we don't want it. And that would be from maybe a foreign government or the court that says, hey, you in the U.S., you're interfering with a criminal proceeding that we have ongoing. Please don't take that type of discovery. And they may.
One thing I've always wondered is it makes sense to be filing these 1782s, if you're going to be on the plaintiff side, be filing these 1782s before you actually file the action. Because once the action's in play, you might get authoritative statement from the tribunal saying, we don't want this stuff.
That's right. And if you go ex parte, and then you get your subpoenas, and then somebody moves to quash, they may come in and try and make that, but it's always harder to get something quashed because the judge has already made their decisions, and sometimes they don't want to have to reconsider.
I cut you off. We're going to finish the other factors.
Sure. Factor 3, is whether the request conceal an attempt to circumvent foreign proof gathering restrictions or other policies of the foreign country or the United States. Now, again, this ties in, not that they prohibit types of discovery. That's not what this type of factor looks at. It looks at if you're trying to get, say, privileged material in another country. That would be a circumvention of a protection of that. The Second Circuit has suggested that proof gathering restrictions are best understood as rules akin to privileges that prohibit the acquisition or use of certain materials, not the absence of a discovery process to get those materials. Courts are disinclined to resolve this factor and also the prior factor based on battles of legal affidavits. They find them speculative, they're very costly, and the courts don't like being in that position. Another important point on factor 3 is that there's no requirement that a section 1782 first go and seek discovery from the foreign tribunal. So oftentimes people will say, hey, judge, don't grant that 1782 discovery because I didn't even try and go get it first in Germany. That's not really what weighs heavily in favor of denying an application. There's no exhaustion requirement that you had to go try and exhaust all other avenues of discovery in the foreign proceeding. And again, there's no foreign admissibility requirement that this information actually be admissible in the foreign proceeding, only that it be somehow useful. And finally, the fourth factor is more of its typical discovery that we're all familiar with, is whether the requests are unduly burdensome or intrusive. Courts will exercise their normal discretion, trim subpoena requests, they'll do their normal gatekeeping function if it strays into privileged materials, and they try to keep it smooth, but oftentimes these things are done on an ex parte basis. You check all the boxes on the statutory, you make good credible showing in the discretionary, judge signs off in the subpoenas, and they can often be very, very broad, which comes in later when people come in and try to trim things back and manage things in that nature.
Just because we talked a little bit about the procedure. So you talked about the ex parte, but it's just really getting an order allow you to do it. I mean, the target might can come in, but is there ever a situation where the other side, if you will, in this other proceeding might want to come in, and how would they do that, and how's that litigation go?
Yeah, many times the other side will, typically in Rule 26, issue a subpoena, and you say you give it to the bank. Banks don't necessarily give that to the persons on whom the information they're disclosing. So sometimes those people never learn that their information has been disclosed. Sometimes the bank, but if you did a 1782 on your account, he's probably gonna call you up and say, hey, these guys are trying to get your business records. Then you come in, you file a motion to intervene, and you try to quash the subpoena. But it's very imperfect, and sometimes people get the information, and the toothpaste is out of the tube at that point, and there's not much you can do.
Thanks.
I think we're moving on now to Chapter 8, if that's okay. That's a great checklist of discretionary factors that can be very useful for litigants and judges alike. We now move to Chapter 8, authors of which are David Zaslowski and Christina Friedman of Baker and McKenzie. David's a partner there, and Christina is an associate. This is a chapter on a subject that is one of the most contested in this whole field of 1782. So, David, do you want to go ahead?
Who's David?
David?
Did we lose David? I saw somebody had dropped. Was that David that dropped? Is he on mute?
No. Is Christina, are you there?
Hello, do you hear me now?
Oh, there we go.
Yeah, I hear you now. Yeah,
sorry
go
about
ahead,
that.
David. You're on.
Yep, okay. I apologize for that little mishap there. I want to thank Christina for her invaluable assistance in putting together this chapter. As Larry said, one of the most hotly litigated issues under Section 1782 is whether the statute can be used in aid of international arbitration. And the reason for all that litigation is what is highlighted in the text. If we move to the next slide, please. What's highlighted there in red, and if you remember back to Rob Smith's presentation.
Oh, go back.
Famous
the previous slide. I think we went
and this is what he was talking about. And it was this footnote from Intel. Prior to Intel, there were two circuit courts that addressed the issue of whether you could use 1782 in aid of private international arbitration. Both held that you could not. The Second Circuit in NBC, the Fifth Circuit in Biedermann. Intel, of course, had nothing to do with arbitration, but for those who had been following 1782 jurisprudence, as soon as they saw this footnote, they recognized right away what was going to happen. And indeed, the 1782 applications started after Intel, in which discovery was sought in aid of private commercial international arbitration.
Can we go forward? Because I got us off track. Because I wanted to show the footnote, but now you're talking about the cases. So the next slide shows the circuit split, I think. If we go to the next slide.
I'm sorry. We'll get to that.
Oh, go ahead. I'm sorry. It's your program.
All right. So let me just make 3 points. The first one is that the argument for using 1782 in aid of arbitration is definitely stronger for investor state arbitration than it is for commercial arbitration. Second point is one of the better arguments made in the cases against using 1782 in aid of arbitration is that it is hard to believe that the Supreme Court intended to overturn the precedent of the only 2 circuit court cases to address the issue, that they intended to do that by referring to a law review article footnote, which again, Rob earlier referred to as clearly as dictum. So it's hard to believe they did it in that indirect way.
Rob was saying it was very important, though.
Directly.
He said it was a very important footnote. I don't know if we want to denigrate that way, right? It's a very important footnote. So, I mean, do you really? I mean, well, here's a question for you: who's right? What do you think the right answer is?
Personally,
I don't think you should commit yourself on that, David. Please.
Is this being recorded?
Yes, it is.
Yes.
Well,
I think you should let the be judicious.
let me make a point in this way. I note that a report prepared by the International Commercial Disputes Committee of the New York City Bar and a number of authors who have already spoken were part of that. Larry Newman, Tim Nelson, Rob Smith were all involved in that effort. And that report expressed the view that as a matter of arbitration policy, even if the courts wanted to allow 1782 in aid of arbitration, they should exercise the discretion permitted to them. And you heard earlier that it is always discretionary whether to grant 1782. So the conclusion of that report was that the court should exercise its discretion to permit, even if they want to permit 1782 discovery in aid of arbitration, they should not do so unless the arbitrators approve the use of section 1782. So
but that's contrary to the discretionary factors, right? Because you don't need permission.
Under the discretionary factors, if you decide that it is
isn't the way around that? Isn't the way around that just to file it before there is a tribunal, so you don't have to worry about asking permission? I don't have to wait. I have reasonably contemplation. I want to file international arbitration.
Yes, absolutely. And then the argument that one would make is, how can you decide the discretionary issue of whether you're circumventing when you're talking about an arbitration tribunal where discovery is always in the discretion of the arbitrators, and especially if you're going to have civil law arbitrators instead of common law arbitrators, how can you possibly know if you're circumventing the discretion of a private tribunal? And so therefore, the court should delay issuing its decision on 1782 until they have heard from the arbitrators. And indeed, there are cases that have so held.
Let me
that's the argument that I would make.
You said investor state, that's more common. Now, what about an investor state arbitration? So there is uncontroversial, right? The investor state, if it's an investor state where you're suing, an ISDS, a country, but what if the the investor state arbitration is actually seated in Washington, D.C.? Does it make a difference?
You said there, Ed, that it's uncontroversial in terms of investor state. There is nothing uncontroversial in the issue of 1782 in aid of arbitration. You find decisions both ways on every issue. So okay. I don't think it's controversial, but I'm sorry, what was your question?
My question does it make a difference if the investor state arbitration is seated in the United States? And so does that make a difference?
If it's seated in the United States?
Yeah, so it's an investor state, but it's at the World Bank. And so is there an argument that it's not really international because we're here?
As I said, cases go both ways on all of these issues, including the issue of whether it is an international arbitration if it's seated in the United States. Of
Right.
course, under the New York Convention, there can be international arbitrations that are seated in the United States. So there's no yes or no answer to that question either. Let me just get quickly to the next slide, because what happened, as might be expected, is there was a split among the courts, first at the DC level, and now also at the circuit court level. You have the Second and Fifth Circuits that say no. You now, in the past 9 months or so, you've had the two decisions of the Sixth Circuit and the Fourth Circuit that have said yes. There are 3 other circuits in which the issue is currently pending. And also in the Servtronics case, there's been an indication that they will be moving for cert. The deadline for that is June 28th. And so perhaps after 16 years of uncertainty, the Supreme Court will be able to clean up the mess that it created.
2 questions. One, has there been a circuit that said it does not apply after Intel? You've got a couple cases that says it does, but has there any cases that followed NBC and the Fifth Circuit after Intel?
Yeah, it's up there on the screen. The Fifth Circuit in 2009 reaffirmed its opinion, its Peterman decision.
Okay, yeah, I guess I was thinking more of a different circuit, but that's fair. They just thought that the Fifth Circuit, in fairness, said they made your point. Well, we don't see the Supreme Court has changed our precedent. That's a little bit different than, another circuit saying we agree, right?
Not necessarily, because the circuits that have gone the other way have said that Intel has, essentially what they've said is Biedermann and NBC were pre-Intel. Intel changed the landscape, and therefore we're not going to follow NBC and Biedermann. Biedermann,
I got one more question for you.
El Paso, and it did not. It said that it's going to continue, that it is bound by, that Intel did not change Biedermann. Second Circuit had a chance to do that. They punted on it, although there's now a pending case before the Second Circuit. So it'll be interesting to see where they go.
We keep on hearing that the 11th Circuit is, the hotbed of this. What's the 11th Circuit say?
Oh, they're a complete mess. The 11th Circuit issued a decision that said, yes, you can. Actually, they did that before the 6th and 4th Circuits. But then sua sponte, they withdrew that case. Ed, I think you know that case well, because I think that was your firm's
Arnie
case.
and I both know the case well. Arnie and I,
so the 11th Circuit is a complete head case on this particular issue.
Yeah, they did that sua sponte. What actually wasn't really sua sponte. It's just that the other side moved for rehearing, and under the 11th Circuit rules, you don't get a chance to respond. So Arnie and I, were just sitting there thinking, and what happened was that there were 2 grounds for the 1782. One was this international arbitration, and the other one was a reasonably contemplated litigation. I forgot now, Arnie, what the district judge had held, but the 11th Circuit originally focused on the international arbitration, and then a footnote said, oh, by the way, you have this lawsuit, which I think the trial judge actually did the opposite, right? The trial judge did it on the lawsuit and said, I'm not going to do the arbitration, right? So the trial judge does the lawsuit, not the arbitration. The 11th Circuit says, no, let's do the arbitration, puts the lawsuit stuff in the footnote. They move for rehearing. We don't get a chance to respond, and then they, issue this, new ruling. There's nothing we can do about it because we quote won. So, we won, the reasoning's different. And they basically flipped it, and they put the arbitration in the footnote, and they put the lawsuit back in the text. So there's the history of the Conacel case, which you claim is crazy, but it's apparently a very important case to some of us.
I think we're maybe ready to move on to chapter 9. The authors of chapter 9 are Matthew Burke and Nancy Hart and Andrea Newman. I think all at Gibson Dunn Crutcher, except for Matthew, who's at Chaffetz and Lindsay. And I believe they're all in New York. the chapters, as you can see, is application of the Federal Rules of Civil Procedure to Section 1782 discovery. And is it Nancy who's going to be speaking?
That's right. That's right. Hi there. Right. So this chapter is really focusing on what happens after you have met the various statutory requirements and gotten past the Intel discretionary factors. The statute itself indicates that unless the issuing court prescribes something different, that the federal rules are going to be applied. And that's been interpreted by the courts of when they are looking at these these discovery requests, that they're going to be guided by the federal rules, most particularly, Rule 26 and 45. That in practice, that means that entities or people who are using 1782 are entitled to get discovery that is broad and liberal as the federal rules apply. As we know, that is generally much broader discovery than is permitted in many other foreign jurisdictions. Generally speaking, people are able to get very broad document discovery. They're able to get depositions, as some of my other co-authors have indicated, even when depositions aren't permitted in the foreign jurisdiction where the proceeding is pending. My co-author, Andrea Newman, was very involved in a case on behalf of Chevron where they used 1782 very, very extensively to get thousands of documents, as well as video outtakes, computer hard drives, internal litigation documents. They were able to pierce privilege in some circumstances. So the ability to get documents and depositions is again extremely broad. That being said, as I indicate, the flip side is that it's not just a total free-for-all, as the federal rules do impose some restrictions. Same with 1782 requests, they still need to meet the various requirements as relevance. It can't be overly burdensome. Courts are sensitive to whether or not it's a fishing expedition. They're sensitive to whether or not the applicant is seeking confidential information, information that might be otherwise subject to a protective order. So they look at if there are any temporal restrictions. And again, they also, when it's a third party, where it's the target of the 1782 is a third party who isn't involved in the foreign litigation, they particularly look at the burden on this third party vis-a-vis the relevance to the foreign proceeding.
Nancy, on this factor, do you see any court looking at it differently than they would normally look at it for any third party dealing with a domestic subpoena? In other words, are they looking at exactly the same law, exact same burden issues that you would see, okay, this is burden, you're not, a dog in the hunt, or they treat it differently because this is, because of the 1782 aspect, or is it simply a Rule 45 analysis and they use the same case law?
From what I've seen, they are treating it, again, after they have gone through the various Intel factors and the statutory requirements, they are looking at it through the view of Rule 45. I think there is some aspect of looking at it in terms of equity, which we'll get to in a bit. But generally speaking, they're looking at it from the point of view is it fulfilling these various requirements under the federal rules. It is true that some courts, particularly within the Second Circuit, are able to have outright denied 1782 applications if they feel that the requests are too broad. Other circuits, the Seventh Circuit in particular, has actually overturned a district court denial of 1782 on the basis that they needed to give the applicant the chance to correct an overly broad request. So there is a bit of a split there. Oftentimes, but again, the courts have wide discretion and they will get involved and impose their own restrictions in some cases.
What about depositions? Depositions are always a challenge. So we already heard from Tom, a lot of these countries, you're not allowed to take depositions, and some of them it's illegal. Brazil, for example, you can't even think about taking a deposition. But here you're going to do them for this Brazilian case. Does that make a lot of sense? Does any courts deal with the fact, okay, we're going to let you have the documents, but depositions, or have they made that distinction? Or let's go ahead, sit down, let's talk.
Not that I have seen where they have really waded into the issue of whether or not, as you know, one of the other chapter writers indicated, the fact that something isn't available in a different jurisdiction is not dispositive here for whether or not something can go forward. You know, there is
some courts we have been able to tell them to stage it. You know, let's see how this goes, and have
yeah, that's true. That's true. They'll say, let's start with the documents and then move on, if necessary, to a deposition, because I think there is sensitivity to the burden. You know, that actually kind of raises the last bullet here, which I think is interesting. Is about reciprocity. So the Supreme Court in the Intel decision gave courts, especially recognized that there was a potential inequity, that a foreign interested party could obtain extensive US style discovery simply by virtue of having as the opposing party someone who has a presence in the United States. And so they gave the courts, district courts, wide discretion to condition 1782 discovery on the applicant agreeing to provide reciprocal discovery to their opposing party. That usually comes up in case when they're seeking 1782 discovery from somebody who's a party in the foreign.
But they're not supposed to be with it, aren't they? That's one of the factors they look at. Is you're a participant, so what are you doing this? So it seems kind of. Is it somebody intervening in? I mean, typically, you know, if it's a bank, they don't care. I mean, I don't think discovery of you. I don't have a dog in this hunt.
It is varied. I mean, in most cases, it's again, they want, if it's going to be reciprocal, it's because the target is going to also be able to use it in the arbitration. There would be really no purpose otherwise. So in the cases that I've seen, it generally speaking, is somebody who is, again, and while that is a factor, it's not dispositive under Intel. So the target usually is somebody who is involved, an entity that is involved in the foreign proceeding or has a substantial interest in it. You know, as the Second Circuit actually just this May in 2020 issued a decision called San Pedro v. Silver Point, where they made clear, it emphasized again that it is absolutely not mandatory that they condition it on reciprocal discovery. Equities are not. It's really within the court's discretion, and that's something that they will look at: is who is going to be, you know, is it fair? Is it going to be? Do they want to have procedural parity to the extent that they can? Again, kind of going back to our very first chapter about the twin aims of 1782.
So
I think we've come to
all the questions that everybody wanted, because we got no chat question at all.
So we do have Ed, we have the drawing, the famous drawing of 2 free books. And by the way,
we do have the winners.
We do have a slide here that helps people order the book. And I don't know whether it's Hannah or Kristen from the Reed Smith backup people who put this on. We're going to announce the winners now of the drawing for 2 free books.
I actually have the winners. I actually have them here. I was touching them.
Could we have one of you announce them?
Yeah, I'll give it to you. Just a second. I'll tell you in a second. Let's see here. All right. Ladies and gentlemen, congratulations. The winners are Thomas Bloom and Stephen Stigich. Congratulations, you are winners of our book. So the rest of you will have to buy it. I know there's a lot of stuff here, a lot of citations we didn't give you. We didn't give you contact information of the authors. All that's going to be in the book. So you're not going to get it for free. We're not going to give you the website either. We're not going to give you the PowerPoint. You got to buy the book. And if you buy the book, you're going to get all the cases that you heard about today, and you're also going to get the update. This is a hot area law. In seriousness, we were almost done. This was supposed to be published late last year, and then these cases came out, and we got delayed, and we all updated our chapters, and then more cases came out, and we said we'll give up. So we're going to have to do an update. So, and then of course the COVID thing delayed it. So we do have a lot of updates to do because we got delayed because of COVID and the publication. So we would have gotten this book out in March. It took a couple of months to delay that. So we apologize, but we will be online. We'll be updating this. So I think it's a great treatise. We're not aware of any other treatise that's doing this. And what we think is really makes this unique as well as the practical nature of it. We think that between all the authors here, among all the authors, we've nailed every hot issue that is here. And we think this is a critical book. And I want to thank all our co-authors who've done an outstanding job. Give yourselves a hand. Congratulations, both in the book and today. It was really amazing work today and in the book. So thank you so much.
Thank you, Ed, for particularly for your questions, which I'm very glad you were available for those, because there's hardly anybody who knows more about Section 1782 than Ed Mullins. He seems to be doing it every day. So I guess that closes things off for us. You know how to order the books, you've been given information about CLE. And if you have any questions, I think you can get in touch with the people at Reed Smith with whom you communicated.
Yeah, one comment. The winner of the book congratulated us on a helpful presentation, but he's biased because he won. But go ahead.
Just one thing. I was watching the chat as well, and somebody said that when you said the code for the participants, that it broke up, and if you could please state it again.
Sure. So if you are interested in CLE, the code is June. June, all caps. June.
I don't know what you do with it, but maybe somebody can tell us.
No, but there was a, prior to the webinar, you were sent CLE forms from Hannon Benson at Reed Smith. And so if you are interested in doing CLE and getting credit for it, the code is June, June. And I also want to thank my colleagues at Reed Smith, Hannah and Jody, who helped us on this as well. As always, they're outstanding and then very helpful. And thank you so much for putting this together for us.
Okay, well, thank everyone.
And thank Juris as well, the publisher. They've been really helpful as well. Thank you so much. And we look forward to having everybody tell your friends to buy the book.
Okay. Bye, everybody.